BNSS Part 3. In this part, we will see Chapter 20 to 29 and from Section 261 to 406. Chapter 20. Trial of warrant cases by magistrate. A. Cases instituted on a police report. Section 261. Compliance with Section 230. Section 262. When accused shall be discharged. 263. Framing of charge. 264. Conviction on plea of guilty. 265. Evidence for prosecution. 266. Evidence for defense. B. Cases instituted otherwise than a police report. Section 267. Evidence for prosecution. 268. When accused shall be discharged. 269. Procedure where accused is not discharged. 270. Evidence for defense. C. Conclusion of trial. Section 271. Acquittal or conviction. 272. Absence of complainant. 273. Compensation for accusation without reasonable cause. Then we will move towards Chapter 21. Chapter 21 is related to trial of summons cases by magistrate. Section 274. Substance of acquisition to be stated. 275. Conviction on plea of guilty. 276. Conviction on plea of guilty in absence of accused in petty cases. 277. Procedure when not convicted. 278. Acquittal or conviction. 279. Non-appearance or death of complainant. 280. Withdrawal of complaint. 281. Power to stop proceeding in certain cases. 282. Power of court to convert summon cases into warrant cases. Chapter 12. Summary trials. Section 283. Power to try summarily. 284. Summary trial by magistrate of second class. 285. Procedure for summary trials. 286. Record in summary trials. 287. Judgment in cases tried summarily. 288. Language of record and judgment. Now, Chapter 13. Plea bargaining. Section 289. Application of chapter. 290. Application for plea bargaining. 291. Guidelines for mutually satisfactory dispositions. 292. Report of mutually satisfactory disposition to be submitted before court. 293. Disposal of case. Section 294. Judgment of court. 295. Finality of judgment. 296. Power of court in plea bargaining. 297 period of detention undergone by accused to be set off against sentence of imprisonment. 298 savings. 299 statements of accused not to be used. Section 300 non-application of chapter. Now chapter 14. Attendance of person confined or detained in prison. Section 301 definitions. Section 302 power to required attendance of prisoners. 303 power of state government or central government to exclude certain persons from operation of section 302. Section 304 officer in charge of prison to abstain from carrying out order in certain contingencies. Section 305 prisoner to be brought to court in custody. 306 power to issue commission for examination of witness in prison. Now chapter 15. Evidence in inquiries and trials. A. Mode of taking and recording evidence. Section 307 language of courts. 308 evidence to be taken in presence of accused. 309 record in summons cases and inquiries. 310 record in warrant cases. 311 record in trial before court of session. 312 language of record of evidence. 313 procedure in regard to such evidence when completed. 314 interpretation of evidence to accused or his advocate. 315 remark respecting demeanor of witness. 316 record of examination of accused. 317 interpreter to be bound to interpret truthfully. 318 record in high courts. B. Commission for the examination of witnesses. Section 319, when attendance of witness may be dispensed with and commission issued. 320, commission to whom to be issued. 321, execution of commission. 322, parties may examine witnesses. 323, return of commission. 324, adjournment of proceedings. 325, execution of foreign commissions. 326, deposition of medical witnesses. 327, identification report of magistrate. 328, evidence of officers of mint. 329, reports of certain government scientific experts. 330, no formal proof of certain documents. 331, affidavit in proof of conduct of public servants. 332, evidence of formal character on affidavit. 333, authorities before whom affidavit may be shown. 334, previous conviction or acquittal how proved. 335, record of evidence in absence of accused. 336, evidence of public servant, experts, police officers in certain cases. Now, chapter 26. General provision as to inquiries and trial. Section 337, person once convicted or acquitted not to be tried for the same offense. 338, appearance by public prosecutors. 339, permission to conduct prosecution. 340, right of person against whom proceedings are instituted to be defended. 341, legal aid to accused at state expense in certain cases. 342, procedure when corporation or registered society is an accused. 343, tender of pardon to accompanies. 344, power to direct tender of pardon. 345, trial of a person not complying with condition of pardon. Section 346, power to postpone or adjourn proceedings. 347, local inspection. 348, power to summon material witnesses or examine person present. 349, power of magistrate to order person to give specimen, signature or handwriting, etc. 350, expenses of complainant and witnesses. 351, power to examine accused. 352, oral arguments and memorandum of arguments. 353, accused persons to be competent witnesses. 354, no influence to be used to induce disclosures. Section 355, provision for inquiries and trial being held in absence of accused in certain cases. Section 356, inquiry, trial or judgment in absentia of proclaimed offender. 357, procedure where accused does not understand proceedings. 358, power to proceed against other persons appearing to be guilty of offense. 359, compounding of offenses. 360, withdrawal from prosecution. 361, procedure in cases where magistrate cannot dispose of. 362, procedure when, after commencement of inquiry or trial, magistrate finds case should be committed. 363, trial of persons previously convicted of offenses against coinage, stamp law, or property. 364, procedure when magistrate cannot pass sentence sufficiently severe. 365, conviction or commitment on evidence partly recorded by one magistrate and partly by another. 366, court to be open. Now, chapter 17. Provisions as to accused person of unsound mind. Section 367, procedure in case of accused being person of unsound mind. 368, procedure in which, in case of a person of unsound mind tried before court. Section 369, release of a person of unsound mind pending investigation or trial. 370, resumption of inquiry or trial. 371 procedure on accused appearing before magistrate or court. 372 when accused appear to have been of sound mind. 373 judgment of acquittal on ground of unsoundness of mind. 374 person acquitted on ground of unsoundness of mind to be detained in safe custody. 375 power of state government to empower officer in charge to discharge. 376 procedure where prisoner of unsound mind is reported capable of making his defense. 377 procedure where person of unsound mind detailed in declared fit to be released. 378 delivery of a person of unsound mind to care of relative or friend. Chapter 28. Provision as to offences affecting the administration of justice. 379, Section 379, procedure in cases mentioned in Section 215. 380, appeal. 381, power to order cost. 382, procedure of magistrate taking cognizance. 383, summary procedure for trial for giving false evidence. 384, procedure in certain cases of contempt. 385, procedure where court consider that case should not be dealt with under Section 384. Section 386, when registrar or sub-registrar to be deemed a civil court. 287, discharge of offender on submission of apology. 388, imprisonment or committal of person refusing to answer or produce document. 289, summary procedure for punishment for non-attendance by a witness in obedience to summons. 390, appeals from conviction under Section 383, 384, 388 and 389. Section 391, certain judges and magistrates not to try certain offences when committed before themselves. Chapter 29, the judgment. Section 392, judgment. 393, language and content of judgment. 394, order for notifying address of previously convicted offenders. 395, order to pay compensation. 396, victim compensation scheme. 397, treatment of victims. 398, witness protection scheme. 399, compensation to person groundlessly arrested. Section 400, order to pay cost in non-cognizable cases. 401, order to release on probation of good conduct or after admonition. Section 402, special reasons to be recorded in certain cases. 403, court not to alter judgment. 404, copy of judgment to be given to accused and other persons. 405, judgment when to be translated. 406, court of session to send copy of findings and sentence to district magistrate. So friends, This is BNSS part 3. In next episode, we will see BNSS last part, part 4. Thank you. Thank you very much.